Honourable Chair, honourable members, I present to you Mr. McBride. He is willing and prepared to testify before you today. Thank you.
May we proceed to administer oath?
Yes, Honourable Chair.
Okay.
Thank you.
Good morning once again, Mr. Robert McBride, and warm welcome.
Thank you, Honourable Chairperson.
The advocate Arens has confirmed that you have been here almost 2 hours earlier. Unfortunately, it happened the way it happened. But let me assure you, the remarks that we made are correct, but they must not unsettle you. They must not affect your presentation. You must be in a very good spirit and focus on the presentation that you have been called to make here. Before we administer oath, let me read the following to you that Mr. McBride, you have been invited to appear before this ad hoc committee, which investigates allegations that have been made by Lieutenant General Ntantla Mkhwanazi. You have been invited to provide information to help the ad hoc committee in its oversight work as it investigates these allegations, among others. 1, the alleged unlawful disbandment of the political killings task team, otherwise known as the PKTT or NPKTT. Number 2, alleged moratorium on the filling of vacancies within the South African Police Services. Number 3, alleged corrupt relationship between senior leadership within SAPS and members of the public. And lastly, political interference in the work of the SAPS. In extending this invitation to you, Mr. McBride, the ad hoc committee chairperson has indicated that you may provide such information to the committee if you so wish under oath in terms of the powers, privileges and immunities of Parliament and Provincial Legislatures Act. Mr. McBride, please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of this inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. Mr. McBride, you are, however, protected in that evidence given under oath or affirmation before a House or a Committee of Parliament may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading, commits an offence and is liable to a fine or an imprisonment for a period not exceeding 2 years. Mr. McBride, you are required to take an oath or affirm that the evidence you are about to give is truthful. Which one do you elect, oath or affirmation?
Oath, sir.
You have elected oath, and may you please follow me as I dictate to you. You shall say I and state your names in full.
I, Robert John McBride,
Swear that the evidence I shall give
swear that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And so help me God.
So help me God.
Thank you so much, Mr. McBride. And welcome Honorable Nomvalo, in your absence, your fellow honorable member David Mandlagaises Kosana has reported about the Senegalese victory over Morocco in the Africa Cup of Nations. Is that the mandate of the party? Honorable Souls, welcome and good morning to you. Advocate Arens and Mr. Robert McBride, our witness, from this table, we have done the part that we should do. We are now going to move to the next phase of presentation of evidence. And then we are going to hand over to you and wish you good luck in the presentations. I will come back to the proceedings at 13 hours when I make an important announcement. Thank you so much.
Thank you. Thank you, Honorable Chair, honorable members. Good morning, Mr. McBride. We have discussed just by way of meeting earlier this morning, the topics which you will address in your oral presentation today, which may not necessarily follow the same sequence that's in your written affidavit. Are you comfortable with that approach?
Yes, Chair.
So perhaps if we could kick off by way of introduction, your current employment?
I'm not allowed to say what my employment is.
Okay. But you still in the public service?
No, sir.
You're not in the
That is an old CV that's there. Yes.
Okay. Your CV is attached as RJM1, and you say that that's an outdated CV.
Yes, sir.
Okay. Just by way of background, you mentioned you hold 2 bachelor's degrees. You also obtained a senior Bachelor of Technology, International Politics at UNISA, Technology at Swani, and you've also completed a number of certificated courses, and all that, or most of that, even in the outdated CV, it's recorded in that CV.
That's correct.
You also mentioned that you're a veteran of the liberation struggle, and that you've been recognized by the Minister of Defense in 2002, and you're a recipient of a number of awards, the most important being the award on conspicuous leadership, star, and the merit medal in silver.
That's correct.
Advocate Arens, just a moment. I see the hand of Honorable James.
Chair, is te vroeg vir ons om so te begin. It's too early for us to be told that the CV is outdated. That means that we have a falsified statement in front of us. And we just continue like it's acceptable.
Oh, okay. Can we take the input of Honorable Skosana?
Thank you, Chair. I just wanted us to, as well, to start in a correct manner, Chair. I think the witness, Mr. McBride, he has to disclose to us as he asked the evidence leader, currently, where is Mr. McBride employed? It can't be a secret, sir.
Yeah.
Thank you, sir.
No, it's fine. Let's get back to the first question. Which CV is an old CV, Mr. McBride?
Sorry, the CV before the evidence leader, sir, is an old CV. I couldn't locate a new one in the time frame that I had to submit it. Just on the issue of employment, if I am given permission to say where I am by my principals, I will say so. So I had raised this issue with the evidence leaders before, and I thought it was taken care of already. I
Okay.
think most people here know where I work.
Okay.
Yeah, but
No.
in order for me to say it,
Let's not conflate issues.
yes,
Let's take them, deal with this issue by issue.
Yeah.
This CV was sent was sent to the evidence leaders by yourselves,
that's
by
correct.
yourself,
That's correct.
and you sent it knowingly that it's an old CV.
And indeed, I told the evidence leaders it's an old CV.
So what is it that must be updated on that CV so that you can place it on record here? We can't argue about that. You can just update it here. Remember, you have taken oath now, isn't it?
Yes,
So any information you give us is under oath. If the CV says you did not pass matric and you have now passed matric, you update it here under oath.
I understand, Chair. With reservations, I'll give you the answer. And
Then we will come back to the second question, which Mr. Honorable Skosana has asked. Let's deal with the part of the CV which Honorable James has raised, because you said it here that it's an old CV. You could not locate your new CV, correct?
yes, indeed, I don't have a new CV. I also don't have my equipment. I didn't have legal assistance. I put it together on my own. It's only the evidence leaders who helped me. So I only sent forward what I had.
Yeah. But even if you don't have your equipment, for instance, now I know where I'm studying. If you ask me, I can say the last time I passed matric was in 1992, and I don't remember anything that happened thereafter.
No, I remember exactly everything.
Yes, that's why we say we want you to update that CV. As the evidence leader, ask you questions, update the parts that must be updated. Because if you start by saying this is an old CV, you are rattling my members. You are unsettling them. Can we proceed that way?
I'm completely in your hands, Chair.
Okay. And then the second question that Honorable Skosana has raised to say, when the evidence leader asks you a question about your current employment, is there any law that prevents you from disclosing where you are currently employed?
Yes, sir, there is.
Can you state it here in front of this committee so that the honorable member may know that you are prepared to give us the answer, but there is a law that prevents you from saying that? You can just say, I'm employed, but in terms of the provisions of this law or this act of parliament, which you as honorable members have passed, I'm not allowed unless I have permission to disclose.
Yes, it's Act 39 of 1994.
Thank you so much.
Chair, that can be a correct citation of an act.
Yeah.
That can be a correct citation of an act. When you cite an act, you can't just say act what of this. What is the act? What is the actual citation of the act? Because what is saying about the number, what number is the act is, and which year was it enacted. But beyond that, Chair, even Google can tell you where he works.
It has a title.
It has a title, Chair. So, but beyond that, Chair, I don't know why should this information be withheld in Parliament, because you can even Google it. It's there. It's a public information where it's employed. So I don't understand this. Thank you.
No. He will state that act, and then each and every act has sections and subsections. You remember, Honorable Ngola, we referred him to Section 17, subsection 2 of the Powers, Immunities and Privileges Act of 2004. So he will also state that act and say, in terms of Section 3, subsection 5 of the act that I have referred to you to, I am being forbidden or restricted to mentioning my employment. Honorable Ngola.
No, thanks, Chair. I think the last part I wanted to submit is that whilst we are starting, let's implore with the witness to stop doing those gestures he's doing. I noticed him when Honorable James was speaking. He's doing some funny gestures of laughing when someone is talking. If he wants us to have a very good day today, he must refrain from doing that. Thank you.
Yeah.
Honorable Chair, can I respond?
What are you responding to?
The allegation about making some gestures. I made no gesture to anyone.
No. You see, you know, you must allow me to guide you so that you know what to respond to.
Yes, sir.
Yeah. The first part of the CV you have responded to, and the advocate will take you through. You will update the parts that you should update. And the second is with regard to Act 39 of 1994. Which act is that one? Act 39.
National Strategic Intelligence Act.
Yeah. Number 39 of 1994. In that act, which are the sections or subsections that prevent you from?
Within the regulations, it indicates we are forbidden to volunteer that we work for the agency.
Is regulations number 10 or number 6?
No, I don't remember. But I was just alerted that I should raise that with you now that I've mentioned it. Yeah. So that's where I work.
Within those regulations, is there a rule that prevents you from disclosing your place of work?
Yeah. In my experience in court cases, you require permission from the Director General in order to indicate, and usually there's an arrangement with the prosecutor that questions about where you work are not asked.
The question that I'm asking is whether there is a rule that prevents you from disclosing.
Yes, there is, and off the top of my head, I don't know the exact number.
Okay. Honorable Cameron, follow up.
Sorry, Chair. Just maybe for clarity, I might quote, the restriction on state security agency employees disclosing their roles is primarily rooted in the Intelligence Services Act of 2002, particularly through its regulations regarding confidentiality and the protection of identity. Thank you, Chair.
So it's not What is the title of those regulations you have referred us to?
Chair, that's part of the Intelligence Services Act of 2002.
It's not the regulations, it's act.
It's an act. I don't know the regulations, but that's what legislation says.
Oh, so you are helping the witness to quote the right legislation.
Actually aiming to help the committee, Chair. Thanks, Chair.
Okay. Did you hear it, the witness?
Honorable Chair, yes, and I'm corrected about the specific number of the act. So I stand corrected.
Yeah. So you withdraw the statement that you earlier made about Act 39,
Chair,
or you are saying they must be read together?
I think all matters relating to intelligence should be read together,
Okay.
always.
Okay. And then, yeah, you were prepared to respond to the matter that Honorable Ngola has raised with you. What is your response on that one?
I seek clarity, Chair, of what is the issues that make the honorable member unhappy.
Okay.
I'm not very clear to me. He spoke about gestures.
Yeah.
Since I came in, I've been holding this chair and not
Yeah.
moving my hands.
Okay. Honorable Ngola, do you have
Thank you
any
very much, Chair.
clarity you want to make?
Chair, when Honorable James spoke about the issue relating to the CV of the witness,
Yeah.
the witness was laughing. And gestures are not only made through hands. When I raised the issue of the citation of the act that is incorrect, he did the same.
Yeah.
So I wanted us to plead with him to refrain from that so that we have smooth proceedings today. Thank you so much, Chair.
Okay. Honorable Nomva.
No, Chair, I just wanted to confirm, firstly, I'm rising on two things. I wanted to confirm that the latter speaker is not hallucinating. We've made a similar observation. Here, we must maintain the decorum. We're not being funny here. We're here to work as members of parliament. Maybe if I can put it in a different way, the witness was making funny reactions using his face. He did that twice. He did it with Honorable James. He did it with Honorable Ngola. So we can't leave it unchallenged because he will do it to me. And when he does it to me, there will be confrontations. So it must be stopped from the onset. That's not how we conduct business of these proceedings. But the second thing, Chair, that I want to raise is that we can't downplay what the witness has done to us as this committee. He voluntarily and he concedes to that incident here before us, submitted a wrong CV to the senior counsel. I was going to understand if maybe you were saying the CV was taken by the senior counsel from somebody else, not from him. He submitted a wrong CV, and for you to prepare the correct CV, you don't need a legal advice because a CV is your own product. You do your own CV. So to me, Chair, the excuse that the witness is giving here is not valid, is invalid, that he had no time, he had no gadgets. And he only tells us now when it has been picked up by one of the honorable members. You should have told this committee before he even spoke that there's an issue with my CV. So we're misled. We were made to read a wrong document as members of this committee because we read before we come here when we prepare for these interviews. So it's an issue that you can't take lightly because if we leave it unchallenged, it's going to be referred to as a precedent in future. There is a precedent that we made here as this committee When Mr. Nkabinde was here, we turned him away because he came with defective documents. Now the same witness, now another witness in the same platform is saying, I gave you a wrong CV, and we just leave it like that. We brush it off as if it's an immaterial issue. So, Chair, what the witness has done to this committee must be condemned with the contempt it deserves. It's wrong. It's not done. He has misled this committee.
Honorable James.
Chairperson, also, the witness couldn't tell us where he works. I don't understand. When his appointment was public, he was publicly appointed as the director, let me help him, director for foreign branch of State Security Agency. It's all over. Why couldn't he answer that simple question? Thank you.
You said that the CV that was sent to the committee is an old CV. Correct.
Chair, in fact, I volunteered indicating it's an old CV. No one pointed it out to me.
That's what you said, that it's an old CV.
Indeed.
Yes. And there is nothing falsified in that old CV.
That's correct.
This is the CV that you used previously.
Indeed, Chair, and I didn't leave anything out in speaking to the evidence leaders.
Yeah.
So indicated my difficulty.
So the period between now and the last time that CV was written, there might have been other developments in your life which may not have been updated in that CV. Correct.
Indeed, Chair.
Okay. And then you say that the various pieces of legislation on intelligence read together, we may find a provision that prevents you from disclosing your employment.
Chair, indeed, but I think the horse has already bolted, and I think Honorable Cameron indicated the correct legislation, and I'm happy with that, sir.
Okay, and Honorable James has also disclosed the position to which you have been appointed to.
That is correct, sir, and I had indicated in volunteering the CV, indicating my dilemma about mentioning where I work. I indicated most of the honorable members know it. It's public knowledge.
Yeah.
Yes, sir.
But you are not allowed to mention it, even if it's public knowledge.
Yes, sir.
Okay.
I'm not, but it has been mentioned now.
Yeah, I understand what you are saying. So, but you are willing to provide information on milestones that you might have achieved from the last time the CV was written.
Yes, sir. Every question, query, clarification on any aspect of my life, I will respond to accurately, including achievements.
For as long as there are no restrictions in law.
Indeed, sir. Thank you.
Okay. Honorable Matthews.
Chair, I think it must be noted, Mr. McBride is very indifferent here as he's sitting here before us. Even how he's sitting, we won't have to go back into the issue of the gestures he's been doing with his face. But the reason and the explanation of submitting to us an old CV and that he did it, he didn't have tools of the trade. You work for one of our agencies of government. literally, it's not that the CV of yours is details and gives job description. So it was a matter of just filling in. Project manager from the Department of Public Works finished on which date, literally 3 or 4 lines. So it tells us, Chair, that Mr. McBride is not taking this committee serious. It's like he's just indifferent. He's just here. Oh, you called me here. It's giving us the same Mary Diaz vibes, what we experienced when we started with Mary Diaz. And we're not going to tolerate that behavior. We can't start off on this note. So we are pleading with Mr. McBride. Please take us serious here as Parliament. Do your work. You didn't, you can't give, I mean, you should even feel embarrassed. You work for our whole state security agency as a whole director. And you even come here and you even just blatantly just say, oh, I didn't have time or I didn't have resources to update my CV and I gave my CV. Can we be taken serious as a country even? So I please address that with Mr. McBride. I think it's very wrong on how you are treating, and it's not Parliament, it's the people of South Africa, Mr. McBride. You can't be in the position that you're in and you cannot even give us an updated CV. It's wrong. And even to address us in the manner that you did, it's wrong. So please let us just move forward. Take this serious. You are talking to the people of South Africa through us. We are representatives. They voted for us. Thank you.
Thank you so much, Honorable Matthys. Honorable members, we are going to move forward in this way. Mr. McBride, members of Parliament have expressed their reservations on the gesticulations that you make in the proceedings. And it is my humble request to you that if there is any conduct that you displayed here which might have offended the members, without any debate, let's restrain from such conduct. Where I stand as the chairperson of the committee, we have not called you here to come and humiliate you. We have not called you here to come and sneer and jeer at you. It is not our intention to cast aspersion on your CV. We have called you here as a citizen of this country who has rights in terms of the Constitution and any other law to have a conversation with you. And I would like you to take this in a very good spirit. As and when we engage with you, there are observations that we will make, but we will always try and raise our observations with you in a manner very reasonable to you, so that when you leave this door after our engagements, you must still feel part of this country and you must say, where I was meeting with the leadership of the people of South Africa. So the last part that Honorable Matthys has said, we all agree that the CV, by your own oral presentation, that the CV is an old CV. Listen to me, this proceedings are not about your CV. I have read you the terms of reference, what we are investigating, but let me tell you why that part is very important. Is because you must make us to believe that you are honestly giving us evidence that will help us. There must never be any shady corners. You must prove to us that you can be a credible witness before this committee. And we are not requesting you to be naked. We request transparency from you. If you can please be transparent without being naked. you are going to help us. So, Advocate Arendse, to propel this meeting forward, we will give the witness a chance to do an oral update of the CV from from the last time that he wrote it, and then complete it. Because you have said that it's an old CV, but whatever details that are provided in that CV, I don't think you are going to change your date of birth. You are going to change your previous employment history. You just say, from the period where the CV ended up to now, I have been at the following institutions, or I have not been anywhere until I got a new appointment this year. Does it make sense, Mr. McBride?
Indeed, Chair. I just have a problem. I smile when I converse with someone quite easy.
That radiant smile is what we want in this. Look at how the chair is smiling. Look at me. Look at me. You see, this is how we smile in this.
I can't help it.
Okay. No, good luck. Good luck, Advocate Arendse and Mr. McBride.
Mr. McBride,
I know we have 2 days with you, but if it's possible for us to finish today, let's finish today, honorable members. Please. The year is still very long. We're still in January. Please. All the best.
Mr. McBride, may I proceed, Honorable Chair? Can I just confirm that with you that you did tell us during our consultation with you was towards the end of last year? I think our consultation with you, the first consultation, I think it was towards the end of last year. But then, because we normally record our consultations with witnesses with their consent, and when it came to that issue, you told us, but then you asked us to switch off the machine. So it's not even in the transcribed notes of that meeting. Did I ever ask you for your CV? And that's why I asked whether you were still employed in the public service, because it indicates your underemployment history from 2019 to present. Project Manager, Department of Public Service and Administration. Now that, according to you, is not the up-to-date employment history. Is there anything else in that CV from pages 33 to 35 which you wish to update and which you are not precluded from doing by any legislation or anything? It's on page 33 or are your pages paginated, Mr. McBride?
Yes, sir. Indeed.
33 to 35. Is there anything else in there that you wish to omit or to include, or is it just that one aspect which is not entirely accurate?
So before being employed by the State Security Agency, I worked for public enterprises investigating corruption within state-owned entities. And to add that, as Honorable Matei spoke, I'm no longer a director in the service. I run special projects.
So with you and Honorable Cameron referring to intelligence legislation, is the effect of all of that you are employed in the intelligence services?
That's correct, Chair.
So when you say from 2019 to present, when did you stop being project manager in the Department of Public Service and Administration?
In 2020. About
2020.
2020, about March.
Okay.
About March, yeah.
So what is missing is this, can we just get absolute clarity on this or certainty?
Yeah.
Is the only thing missing from your CV, your employment status from March 2020 to date?
No, from 2020 March until July 2020. That is the public enterprises.
That's yeah, when you were investigating
Yes,
SOEs.
yes, yes.
Okay. And then after that, is that in the intelligence?
That's when I went into
Into
the
intelligence.
intelligence community,
Okay.
yes. Formally.
Okay. Can I request that we get an updated CV from you, please, if not by the conclusion of the evidence shortly after, for the
Okay.
record?
Indeed, no problem.
Is that the only omission from this CV?
Yes, yes.
Now, I was going to come to this, not because of your CV, but I'm sure the honorable committee members would also have noticed that your CV and this statement is silent on the period between 2008, when you were last the executive head of the Ekurhuleni Metro Police, and then on 3rd March 2014, when you took office as the executive director and accounting officer of IPID, the Independent Police Investigative Directorate. Explain to us what that gap.
Yeah, so I was in private sector. I had my own company, but I would work as a resource person in the subcommittee of the NEC of the ANC dealing with public safety issues. And I would assist with policy formulation. It's during this period I was invited to apply for the executive director post of IPID.
Yeah. So between 2008 2014, you were employed in the private sector.
That's correct.
Okay. Then you had also been released from, you served time in prison.
That's correct.
And you were released, and between 1992 and 1994, you were employed by the African National Congress as a coordinator at the ANC Peace Desk in Gauteng. You then subsequently, 94, 95, also became an MPL, member of the provincial Gauteng provincial legislature. And then subsequently,
sorry, Chair, just one issue. In 1995, I became a member of the National Assembly for a few months, and then I went into the civil service in the then DFA Turco.
Let's get the microphone closer to your mouth. The closer you get, the better.
Okay.
In June 95 until October 95, you were appointed as the head of the DIA committee, which was tasked with negotiating and coordinating the integration of the ANC overseas trained officials into the Department of Foreign Affairs.
Yes, that's correct.
And between 95 and 2003, you also held a number of positions within DIRCO, that's the Department of Effectively Foreign Affairs, and you became a director for the Southeast Asia office in Pretoria.
That's correct.
Then in 2003 to 2008, it's almost 5 years, you were appointed as the executive head of Ekurhuleni Metro Police.
That's correct.
Until 2008. just as a matter of interest, during that period, did you come to know or encounter Julius Mkonazi?
Yes, whilst I was at Ekurhuleni Metro Police Department, Mr. Mkwanazi, I think his rank was superintendent, and he dealt with the public order policing. He was the head of the specialized services public order policing. It was a platoon size, about 32 people. And he was operationally deployed. So he would head it whenever there's a disturbance, then they would deal with it.
But that was within the Metro Police, fell under Metro Police.
That's correct, yes.
Doesn't have police powers under the SAPS Act.
No, the Metro Police is established due to the SAPS Act, is born out of the SAPS Act. So powers are then devolved to it by the national minister, and training standards are prescribed by the national commissioner.
All right. All right, we'll ask Mr. Mkonazi a bit more about that. Then on the 3rd of March 2014, you took office as the Executive Director and Accounting Officer of IPID, the Independent Police Investigative Director. How did that come about? Was that a job that was advertised? Did you have to apply? What were the procedures that were followed?
Yes, there was an application. We applied. We had interviews. I don't remember the other interviewees. We were kept in separate rooms. I think on the panel was Minister Mtetwa and Minister Kuele. And I think there was an official from State Security, Sonto Kujo, and someone from HR of the police department, the SAPS department, yeah.
Honorable Skosana.
Thank you, Chair. I just wanted a clarity from our witness, Mr. McBride. I think, if I heard well, he said that he served in this parliament shortly before he left. You said that you served shortly here in the National Assembly, am I right?
That's correct, yes.
So hence, Chair, the issue of a CV, we have to go back to it. Because on the CV, there's nothing like that. It's only the one which I know that you serve in the provincial government in Gauteng. But the issue of the National Assembly, on this CV, there's nothing. Unless, Chair, you say that we will perhaps after lunch, go back to this issue of the CV, because I can tell you now, Chair, we are having something which it's completely wrong before us. Hence, I'm saying other people don't. I mean, us as sitting here, I know that Mr. McBride served between 1994, after the democratic elections in this country. He was in the Gauteng legislature. It's here. Even if he served for a day here in the National Assembly, but he was supposed to be here. But it's your decision, Chair. But I was just raising that perhaps this CV has to be rectified, because otherwise we're going to mislead ourselves here. Thank you, Chair.
Honorable Shonga.
Thank you, Chair. Sawubona, Chair, and my members. Mr. McBride, how is it? Just clarity here. I don't know whether while I'm still contemplating with accepting the CV or not. You say you were a member of parliament. Which party were you in at that time? And did you resign before you got employed in this government?
I was a member of the ANC.
Still a member of ANC.
I'm a member of the ANC, yes.
Thank you very much. May the record keep that, Chair. That ANC members are working or worked in the head of State's Department.
The part that you were here in the National Assembly, does it reflect on your CV, or is Honorable Skosana correct that that part is missing in your CV?
No, it's correct that it's not reflected on my CV. And I was there for a very short while, for 5 months or so, before I was tasked to deal with the integration. So perhaps I should have included a short period, yes. I was sworn in. Yeah,
You have been here in Parliament,
yes, sir.
the National Assembly.
That's correct.
Yeah, that part must be in your CV,
Okay, sir.
especially that it is not a part that falls outside the period that you say had to be outdated. I mean, it had to be updated. It falls within the period which by now was supposed to be reflecting in your CV. Yeah. So I'm going to say that, like I said, honorable members, let's have focus. We are going to allow the advocate to continue with the proceedings because we want to deal with evidence that you must present here. And that part of the CV, sometimes between today and tomorrow before you leave here, we must be having a detailed CV that is up to date. Is that correct, Mr. McBride?
Understood, sir.
Okay. Thank you.
Thank you, Honorable Chair, honorable members. So when you were appointed as the head of IPID, you describe, can I ask you to look at paragraph 34 of your affidavit? Just give us a brief overview of IPID.
So I have it. So IPID provides independent and investigative oversight over the South African police services and municipal police services. Its independence is entrenched in the Constitution of the Republic of South Africa, and it is essential to ensure lawful function of police services in South Africa.
Who was the Minister of Police at the time of your appointment?
It was the late Minister Natim Tetwa.
Then at paragraph 36, you say that it is under your leadership that IPID for the first time took on corruption and systemic corruption within SAPS. Do you want to expand on that?
Yes, sir, indeed. It was the first time it was taken on. In fact, at the end of my tenure, there was between 8 and 13 generals and about 10 brigadiers of senior police officers who were on trial for corruption. Never been done before. Should have been a national emergency. and no new cases since I left IPID have been taken up again, which involve systemic corruption and corruption.
Now, you also mention, and it's apparent from the from our consultation and from the documents or documentary evidence that you've submitted from our annexure and exhibit bundle, that much of what you're going to say has been ventilated in public and in various litigious matters here before Parliament, and also the Zondo Commission.
That's correct.
Your affidavit before the Zondo Commission is at RJM 4, Annexure RJM 4, which is dated the 13th of February 2019, and which is at pages 120 to 152.
Yes, that is correct. Yes.
Then can I take you to page 123? We're still dealing with your appointment.
I have it.
And paragraph 18.
I have it, yes.
Now, just prior to your appointment, this is at paragraph 16, and unknown to you on 22 January 2014, you commenced your employment in March 2014, is that right?
3rd of March 2014, yes.
Yeah. IPID had issued a progress report on the so-called rendition case. In this matter, it was alleged that Generals Dramat and Sabia were implicated in the planning and execution of the 2010 operation that led to the illegal repatriation of 5 Zimbabweans. In this progress report, it was recommended that Dramat and Sabia be criminally charged with kidnapping and defeating the ends of justice.
Yes, indeed, sir.
And then at paragraph 18, you want to read from paragraph 18?
Upon my appointment, I asked to be briefed on all high-profile cases. One of the cases I was briefed on was the rendition case mentioned above in paragraph 16. After the briefing, it became clear to me that the investigation had not been conducted independently and impartially in line with the IPID Act. This was because members of SAP's crime intelligence had conducted the investigation and had presented their case file to IPID. In the case file, there were some statements that appeared to implicate Dramat and Sabia. I was not satisfied with this, as CI do not have an investigative function, and this smacked of an attempt by CI to present their work as work of an independent IPID.
So in your affidavit before Judge Zondo, you deal with the issue of Generals Dramat and Sabia from paragraph 19, and at paragraph 22, which is on page 124 of the same document.
Yes, yes.
You refer to 21 rather. On 18 March 2014, IPID issued a final report to the National Director of Public Prosecutions on this matter, which effectively exonerated Dramat and Sabia. The findings and the recommendations in this report were based on a thorough review of all the available evidence and additional evidence gathered by IPID. The final IPID report that I later issued later contradicted the position of the then Minister of Police, the late Honorable Nhleko. Sorry, not Nteto. Who stated, Minister Nhleko, who stated that IPID recommended that Ramat and Sabia be criminally charged with kidnapping and defeating the ends of justice. So you took issue with that. Do you want
The
to?
key element of the difference in the two reports was that the first report could not have been finalized because cell phone record analysis report was not added to it or factored in. Point being, the cell phone analysis report could either implicate further or exonerate. It was not factored in. So on reflection and on study of the report, which had not been added initially, it was clear that General Sibia was not anywhere near the scene of crime. And it appeared to be a stitch-up. He was getting framed for a case he had nothing to do with. In fact, the people making statements against him were the very people who, together with one of the DPCI guys, handed the people over unprocedurally, irregularly, to Zimbabwean authorities.
Your affidavit and other supporting affidavits and other reports also form part of the court record in a matter. I want to refer to RJM 7 on page 288. That is a High Court judgment of Madam Justice Kathri Setlowani.
Yes, I have it.
It was a judgment delivered on the 4th of December 2015. As indicated in the head note of the reported judgment on page 288, the learned judge says this application concerns the independence of IPID, which is a statutory body established to investigate alleged misconduct and offences, including corruption committed by South African Police Service. Central to the question of IPID's independence is whether certain aspects of the legislative machinery regulating IPID afforded independence required by the Constitution. Then there's a reference in paragraph number 2 that when you took office, you became responsible for a publicly controversial IPID investigation into the alleged involvement of Lieutenant General Dramat, the then Director of Priority Crimes Investigation, DPCI, Major General Sabia, the provincial head of DPCI. Then is a short recordal of how the investigation panned out. She says that Advocate Mo Singh of the NPA was responsible for overseeing the investigation. That's the IPID investigation. IPID sent Mo Singh an investigation report dated 22 January 2014. That's the January report. That's the first report.
Yes, indeed.
That's what is called the Kuba report.
Yes, yes.
The report, which was signed by Kubeka, concluded that Ramat and Sabia were involved in the illegal renditions and recommended that they be criminally charged with kidnapping and defeating the ends of justice. A subsequent and final investigation report on the matter, dated 18 March 2014, was signed by Kubeka, Mr. Matthew Sissoko, Chief Director, and McBride, and submitted to the NDPP on 13 April 2015 for a decision on prosecution The report concluded that there was no evidence to suggest that Sabia and Ramat were involved in the illegal rendition of the Zimbabweans and recommended that no charges be brought against them.
The only correction is that the report is finished the 18th of March, but I signed it before handing it over to Masana on the 9th of April.
Okay. I was just reading from
Yes, sir.
the judgment.
Yeah, no, I just mentioned it for completeness,
So,
lest it may appear that I might be omitting things.
as long as it's not intentional or intended to mislead,
No, definitely
we
not.
all suffer from that fault line. Then this goes on to say that the Minister of Police, who is the first respondent in this application, had serious concerns with the recommendations in the March report. That's the final report.
Yes, sir.
In relation to Ramat and Sabia, as they were inconsistent with the recommendations of the January report. Relying on the January report, an investigation which he had commissioned Waxman's attorneys to conduct on the production of the two investigation reports, the minister initiated a suspension proceeding against McBride for alleged misconduct and placed him on precautionary suspension on 24 March 2015, just after a year after he took office. Then the learned judge references the powers or the statutory powers on which the then minister relied. You received a notice to attend a disciplinary inquiry, including a charge sheet. Then she goes on to say, in instituting the disciplinary inquiry, this is on page 289, Honorable Chair, Honorable Members, at the top, the Minister relied on the same removal power, Section 66A of the IPID Act, read with the provisions governing disciplinary proceedings under the Public Service Act and the IPID regulations. And this was the charge. The charge sheet, the charge against McBride is essentially that McBride improperly altered or caused the alteration of the recommendations, findings, and evidence in the March 2014 report to protect Ramat and Sabia, and that he gave instructions to Kubeka and Sissoko to act in a manner for the same improper purpose. The merits of the charges are denied by McBride, Kubeka, and Sissoko, are not at issue in this application as they are subject of a disciplinary inquiry instituted by the Minister to be determined in due course. It is, however, the Minister's suspension of McBride and the institution of disciplinary proceedings against him which have led to the relief sought in the present application. Do you want to comment any further on this?
Yeah. So indeed, the High Court mainly dealt with the aspects relating to the minister's unilateral right to institute disciplinary proceedings, and that it gave too much power to the minister and removed the independence. And in this particular case, the minister disagrees with the recommendation and therefore moves to discipline. So those are the key issues, really. The minister, for an independent body, cannot interfere or suggest the outcome of an investigation. It's beyond his powers, in particular in an organization that's like IPID, which is a creature of the Constitution.
So in that matter, the High Court had set aside your suspension,
That's correct.
with the rule that it was invalid and unconstitutional, and that the minister didn't have the powers to suspend you
That's correct.
because of the independence of IPID.
Yes.
The matter was escalated to the Constitutional Court, which is Annexure RJM2 at pages 36 to 65. That is a judgment for the full court, unanimous judgment by Justice Bosciello. Have you got it, Mr. McBride?
Yes, sir, I have it. Thanks.
The order of the Constitutional Court, which was decided on the 6th of September 2016, is at page 37, declaring those provisions set out on that page as invalid, to the extent that they authorize the Minister of Police to take disciplinary steps pursuant to the suspension, or to remove the Executive Director of IPID. And Parliament was also directed to cure the defects in the legislation within 24 months. On page 38 at paragraph 4, the order reads that it is declared that the decision of the Minister of Police to suspend Mr. Robert McBride from his position as Executive Director of IPID is invalid and is set aside. Now, just for the context, because although IPID is independent, the court makes it clear that it doesn't mean that IPID is not accountable.
That's correct, sir.
Because we are dealing here also going to deal with allegations that IPID itself was infiltrated, and there's allegations that IPID is controlled by one O'Sullivan, Paul O'Sullivan.
Yes, sir.
And that there's some external influence. Now, at paragraph 24 on page 51, the court says that IPID is an independent police complaints body established in terms of Section 206 of the Constitution. Section 4(1) of the IPID Act requires it to function independently of SAPS. This is to ensure that IPID is able to investigate cases or complaints against the police without any fear, favor, or prejudice, or undue external influence. Section 4(2) of the IPID Act requires that each organ of state assists the Directorate to maintain its impartiality and to perform its functions effectively. Importantly, Section 2 of the IPID Act requires IPID to play an oversight role over SAPS and municipal police services. Given the nature, scope, and importance of the role played by police in preventing, combating, and investigating crime, IPID's oversight role is of cardinal importance. This is aimed at ensuring accountability and transparency by SAPS and municipal police services in accordance with the principles of the Constitution. Then at paragraph 26 on page 52, the responsibilities of the Executive Director is set out in that paragraph. Then the court references the role played by the minister and that the executive director is required to submit an annual report to the minister within 5 months at the end of the financial year. This is on page 53. Evidently, this is intended to ensure that the executive director accounts to the minister about activities within IPID. This is probably because the minister, as the political head of the police, bears political responsibility for the police. But it's the next paragraph which I want to highlight, paragraph 28. But this on its own undermines, does this on its own undermine IPID's independence to a point where it offends Section 206 of the Constitution? And the court says emphatically no. The fact that IPID is required both by the Constitution and the IPID Act to be independent does not mean it cannot be held accountable.
That's correct.
Like all organs of state, IPID must be accountable for its actions. To be insulated from undue political interference or control, that's correct, does not mean that IPID should be insulated from political accountability. Accountability is one of the important values enshrined in our Constitution, a basic tenet of good governance. Hence, the requirement that it must submit reports about its activities to the minister, who in turn will place them before Parliament. Then, at paragraph 31 on page 54, the court asks and answers the question, what then does the independence of IPID mean? Does it mean complete or sufficient independence? Admittedly, it is difficult to attempt to define precise contours of a concept as elastic as this. It requires a careful examination of a wide range of facts to determine this question. Amongst these are the method of appointment, the method of reporting, disciplinary proceedings, and method of removal of the executive director from office and security of tenure. Then the court references some important cases preceding this case, the Alan Suzman Foundation case and the Glenister 2 case. At paragraph 38 on page 57, comparing and contrasting IPID with the DPCI, Hawks, the court says that Section 6 of the IPID Act gives the minister enormous political powers and control over the executive director of IPID. It gives the minister the power to remove the executive director of IPID from his office without parliamentary oversight. This is antithetical to the entrenched independence of IPID envisaged by the Constitution, as it is tantamount to impermissible political management of IPID by the minister. To my mind, this state of affairs creates room for the minister to invoke partisan political influence to appoint someone who is likely to pander to his whims and who is sympathetic to the minister's political orientation. This might lead to IPID becoming politicized and being manipulated. Is this compatible with IPID's independence as demanded by the Constitution and the IPID Act? And the court says certainly not. Paragraph 39, to subject the executive director of IPID, which the Constitution demands to be independent, to the laws of governing the public service to the extent that they empower the minister to unilaterally interfere with the executive director's tenure, is subversive of IPID's institutional and functional independence, as it turns the executive director into a public servant subject to the political control of the minister. Without adequate independence, it would be easy for the minister to usurp the power of the executive director under the guise of exercising political accountability or oversight over IPID in terms of 206 of the Constitution. In this case, acting unilaterally, the Minister invoked the provisions of Section 16A1 of the Public Service Act, placed McBride on suspension, and instituted disciplinary proceedings against him. Undoubtedly, such conduct has the potential to expose IPID to constitutionally impermissible executive or political control. That action is not consonant with the notion of the operational autonomy of IPID as an institution. Put plainly, it is inconsistent with Section 206 of the Constitution. It follows that it is invalid and must be set aside. And then the last paragraph I want to refer to, paragraph 43 on page 59. To my mind, the cumulative effect of the impugned sections has the potential to diminish confidence the public should have in IPID. As the amicus curiae emphasized in its submissions, both the independence and the appearance of an independent IPID are central to this matter. The manner in which the Minister dealt with Mr. McBride demonstrates without doubt how invasive the Minister's powers are. What exacerbates the situation is that he acted unilaterally. This destroys the very confidence which the public should have that IPID will be able, without undue political interference, to investigate complaints against the police fearlessly and without favor or bias. IPID must therefore not only be independent, but must be seen to be so. Without enjoying the confidence of the public, IPID will not be able to function efficiently, as the public might be disinclined or reluctant to report their cases to it. Do you want to comment on this? Because this also speaks directly to some aspects of the Honourable Committee's terms of reference. How does one, or how does this committee recommend to Parliament that trust and confidence be restored, not only in the police, but also some of the other arms of security in the country?
So, for example, the GPCI is still under.
Honorable Matthys.
No follow-up question. Just senior counsel, please speak into the mic. You extra soft today.
Sorry, Honourable Matthys. My apologies.
So, in response to the question, Honourable Chairperson, it's a good example about non-implementation of Constitutional Court judgment is DPCI. DPCI is still under the National Commission of Police. DPCI is, its own budget is controlled, it's on the same budget as SAPS. It doesn't have, as this judgment indicates, structural and functional independence. When GPCI has to appoint a specific person, GPCI has to ask SAPS HR to stand in and decide. So we've contravened a number of judgments on that. In the issue of IPID, and as we've seen in recent years, IPID should move away from Minister of Police, as the Minister of Police is the head of a department, political head of a department, over which IPID has investigative oversight. including criminal investigations. And therefore, the minister would have an interest in controlling the outcomes. And that is our experience within IPED, various stages and various forms. And perhaps later on, I will come to that during questioning. So those are the issues. So there's still some outstanding legislation, probably for the work of the National Assembly to correct and implement so that we do not have a repeat of inquiry after inquiry when police systems go wrong. And in that way, we need to fix the systems first. And a clear way to fix the system is the anti-corruption bodies need to have the necessary independence to be able to exercise an investigative oversight over them. If it's not there, it's just another form of control by the minister. Indeed, the forerunner to IPED was the ICD, which was part of the SAPS, and it took a lot, and it's still work in progress to get the mind of independence of IPED workers right, because there's still, some of them still have relationship with SAPS, and it goes to them being colleagues before and so on. And so it does affect their work. So, yes.
Thank you. Just to round off on the rendition issue of Ramat and Sapia. Sorry. Can we just reference at items 8 and 9 of the index annexure RJM 6A and RJM 6B. 6A is the rendition report. At page 186 to 213, and the Waxman's report is from 214 to 287.
Yes, I have.
So this particular report on page 186 that was the first January 2014 report.
Yes, yes.
And one can see from page 213 on page 213 Mr. Kuba, then the acting provincial head of IPED Limpopo, said based on the available evidence, IPED recommends that Lieutenant General Ramat, Lieutenant Colonel Maluleki, Constable Khadebi, Captain Kosi, and Warrant Officer Maku be charged criminally of kidnapping, defeating the ends of justice, assault, and theft. And of interest is at page 207. At page 207, there is a statement, a reference to statements taken of senior members of SAPS. And you'll see in the middle of the page, Lieutenant General Nkwanazi.
Yes, sir.
Do you want to comment on that passage? Or do you want to read it again?
Is that 5.6?
5.6, yes.
Okay. So in context, this is Kuba writing about his interaction with General Mkwanazi then, and what General Mkwanazi will indicate about his knowledge of the rendition. He would state that in late 2011, when he was acting National Commissioner of the South African Police Services, he heard news when Minister Khadebe was commenting about the alleged death of a Zimbabwean citizen as a result of being handed to Zimbabwean authorities by South African Police Services. He immediately contacted the head of DPCI, Lieutenant General Dramat, and inquired about the issue. Lieutenant General Dramat confirmed that members of his unit did transport Zimbabwean citizens, but as illegal immigrants. He then summoned General Dramat to his office. Lieutenant General Dramat came with an officer who was introduced to him as Cowboy. He was informed that Cowboy was in charge of the group that transported Zimbabwean citizens. Cowboy said that he was investigating a case of ATM bombing, which led him to the Zimbabwean citizen. After he realized they were not linked to the case, he decided to transport them to Beitbridge because they did not have valid documents. Cowboy further said that he got valid deportation documents from Home Affairs before he could transport them. He would state further that he could not understand why Cowboy did not hand over immigrants to Home Affairs when he asked whether it was necessary to transport illegal immigrants. Lieutenant General Dramat could not offer any explanation.
So there wasn't any further or other input from General Nkanazi to Cuba?
No, so according to these documents, no.
Okay. Then the next reference is the Waxman's report on page 214. There's no reference to Mkhonazi or whether or not he was interviewed in the compilation of this report.
Not that I'm aware of yet.
And this report also recommends, and it's apparent from page 285, the section on recommendations.
Yes, I have it.
You see that Dramat, for the reasons set out at 531, we recommend that both criminal charges and disciplinary charges be brought against him in his capacity as an employee, and similarly for Sabia.
Yes.
Now, the third report is the one that is not an annexure, Honorable Chair, Honorable Members, to the affidavit, but we have now included it late in the exhibit bundle. So I'm sure that hopefully by the time you ask questions of Mr. McBride, you would have had an opportunity to look at that report. That's the final report.
Yes, indeed.
Did you interview, amongst others, General Nkhonazi in the compilation of that report?
No. I was not involved directly in the investigation, and I'm not sure if the others spoke to him again. What was done was the inclusion of the cell phone records analysis report to indicate whether the cell phone analysis report will confirm the suspicions or exonerate the suspects. And in this case, so even what Kuba did, he took the official phone of Sibia, and unbeknown to Sibia, the number of the private phone, and checked both of them. Those phones were together all the time. And They were nowhere near the crime scene as explained by witnesses. So it's not sustainable any longer to continue to suspect him and recommend prosecution.
Now, can I ask you to turn to Annexure RJM 8, which is on page 305. That is the affidavit or the sworn statement of Matthew Sissoko, an affidavit that he made to the Zondo Commission.
Yes, sir.
It's at page 307. And that affidavit was deposed to on the 20th of November 2019. That you can see from page 314.
Yes, sir.
And he mentions at 307 paragraph 2, he says at the onset it was important to note, he introduces himself and says, I'm responsible for all provincial and national investigations of the directorate. I report directly to the executive director. Is that still his position? Do you know? Mr. McBride?
No, my understanding is Sissoko is now part of IDEC. As a permanent staff member in IDEC and head of investigations.
He says at the onset, it's important to note that I specifically asked the lawyers who were interviewing me what the status of the inquiry was and whether I was being investigated for misconduct or any criminal offense. To which they replied that the minister merely wanted to understand the circumstances surrounding the two reports. Then he also attaches a transcript of the interview. And he only participated without legal represent on the basis of this assurance. In paragraph 3, this notwithstanding, when the report was released, which was not officially given to us, but rather leaked to the Sunday Times newspaper, it was recommended that I be charged criminally and departmentally without even affording me an opportunity to deal with the allegations against me. When you objectively look at the totality of the evidence in this matter, it is apparent that although Kuba signed the so-called first report with the recommendation that Ramat and Sabia should be charged, he regarded the report as an interim report, as he was aware that investigations were outstanding. Mosing and Moletsi came to a different conclusion relating to charging Sabia, concluding that there was no evidence to support the charge and also indicated that expert evidence on cell phone records needed to be procured. They both regarded Kuba's so-called first report as a draft report and marked it as such. The report emailed to me by Kuba after sending the so-called first report to Mosing does not recommend charging Sabia. See the email and the report attachment marked in S3. What was sent to me was his amended first report, which amended the recommendation that Sabia be charged. The decision arrived at by both Mzinyati and Beloye. Were they at the time prosecutors, Mr. McBride?
Yes, sir.
In the NPA?
That's correct.
Without having regard to the so-called first report signed by Kuba and the final report signed by myself, Kuba, and McBride, is different from the recommendation of Mosing and Moletsi, as they decided that both Ramat and Sabia should be charged. So too the report, which is the final report signed by myself, Kuba, and McBride, concludes differently, that there is no evidence to support the charges against Ramat, Sabia, and other officers. So what was Mr. McBride, what is the upshot of all of this?
Is that the NPA itself, senior members were also of the view that it was an incomplete report. And they said so in writing, and some even wrote the word draft. And it's therefore no surprise that when the additional evidence is added, which shows a different perspective on the matter, that the recommendations from IPUD would be that charges against Sibia and Ramat are not sustainable. There's no evidence to sustain it. So that's it. But it shouldn't be a surprise. Now, just for completeness sake, Chair, this matter has been ventilated in this august house before the portfolio committee ad infinitum. And it's on and on about it. When I requested that I should come and explain this, what's explained in the Zondo Commission, Mr. Bjekman refused to let me come and explain the side. So they started a long process which then culminated in my suspension then, together with Werksman report. No consideration of the totality of evidence that was there. So, and it's not the first time, and it happens a few times. Honorable Chairperson, in this august house, it happens a few times when that happens.
Just explain to us, Mr. Beekman, those of us who, people who may not know who you're referring to.
Oh, Mr. Beekman was the executive director of IPUD before me, and also became a chair of the portfolio committee of police. Prior to that, he was a National Party member, and with the collapse of the National Party, he joined the ANC. Was during, I think, floor crossing period or something. So he was beholden to be told what to do, and so he closed his mind.
Honorable Sangoni.
Thank you, Chair. Good morning, Mr. McBride. Sorry, that sentence sounds incomplete. Through you, you said he was beholden to be told what to do. By who?
I reckon by my fellow comrades in the ANC, who had convinced themselves by whatever they were told by. The then senior member of the ANC, Nkosinati Nhlego,
Honorable James.
Thank you, Chair. I raised my hand earlier on, I think twice. You didn't recognize me, and I'm going to go back to the same question because it's relevant now. You mentioned that there was a plot against General Sibia, and you mentioned that all the statements given was incorrect by the members within SAPS. Who were these members?
the people who made the false statements.
Yes.
So it was, I don't remember the names off by heart yet, but it was the same people, and that's what Kube explained to me. At some stage, General Sibia, and here's where the problem starts, arrested General Mdluli, Richard Mdluli. And during the appearance of Richard Mdluli in the court in Johannesburg, a number of armed people were putting the proceedings under surveillance, and Sibia and his fellow officers approached them, and an altercation ensued, ultimately which led to the arrest of those people. And those people describe Sibia in a particular way. a tall man in a gray suit and driving a BMW. Now that same description of him mysteriously comes up by the same people of crime intelligence. By the way, those people of crime intelligence, honorable member, they were crime intelligence members, and the name comes up again in this rendition issue as the statement supposedly implicating Sibia. But where they placed Sibia on the scene, Sibia is 100 kilometers away from the cell phone records which were obtained subsequently. So in my mind, it's a stitch up. It's a fabrication. And that's what, according to Kuba, what gave him an idea to look is that he investigated both cases. So that's how he remembered the statement in the other one. And then it became clearer afterwards when we got the cell phone records. It can't be, unless General Sabia has the ability to bilocate and be in two places at the same time.
Okay, Mr. McBride, you can stop speaking. I want to give you a break, honorable members, and because this is your time now, let me check, is there any one of you who wants to speak? This is your time.
No, Chair, just to remind the witness to mind the mic. Only that, Chair, nothing else.
Okay. Any other, are you satisfied, Honorable James?
Not quite, Chair, because political interference and factions is what we are probing within SAPS. And Mr. McBride takes us back to 2014, and he says that the factions actually started then, and it kicked off with the arrest of Richard Ndluli. And this is why I'm asking names. If you're saying it started then, are they still employed within crime intelligence? And you also specifically mentioned crime intelligence, and that is where the rot is today and the people that we are dealing with. Are they still employed within crime intelligence? Okay, thanks.
My apologies, Chief Whip. I can't say definitively, but from my knowledge, they still are.
I want to get indication from you, Honorable James. Are you satisfied? Anything, Honorable Sauls?
Partially satisfied, Chair. I just would have wanted
Anything,
name.
Honorable Matthews? Honorable Ntuli?
No, nothing on my side at the moment.
Honorable Mngango?
Well, nothing on my side. Thank you.
Honorable Sangoni?
No, nothing, Chair.
Honorable Sokanyile?
Nothing, Chair.
Honorable Ngola?
One thing, Chair, let's go to a break.
Honorable Nomvalo?
Nothing, Chair.
Honorable Shongwe?
Nothing, Chair.
Charlie?
I think I must take a little bit of time to really make some follow-up questions, which might take around 15 minutes, Chair. Do you allow me?
No, it's your time, I mean.
Thank you, Chair. So no member should intimidate me then. I really thank for the opportunity, but I'll come back at a later stage. Thank you, Chair.
Honorable Breitenbach? Honorable Kwala-Barnard? Honorable Cameron? Honorable Klopa?
I'm fine, thank you, Chair.
Honorable Vessels? We will come back at 14 hours. Thank you so much, Advocate Arendse and our witness, Mr. McBride. Thank you.